Thank you, Mamta, and thank you everybody for joining us today on a discussion on a very important topic. I think it will be the first time once the government fully approves the direct listing of Indian companies on offshore security exchanges, something that's not happened before. We, as Indians, were allowed previously to list depository receipts, ADRs and GDRs as they're known, offshore, but we've never actually been, Indian companies have not been able to list their equity securities offshore directly. This is going to be, it's already approved by the Indian cabinet, but there are certain amendments that are required in various regulations that are still pending for approval, and we don't yet have the details. But knowing that the government's working on it, we thought it's important enough to get our experts to start talking about what are the key issues to think about in this regard. The key beneficiaries of this, of course, are going to be the Indian tech companies, the unicorns that India has been able to grow organically and that have not actually set up outside India, which has been the trend to be able to list offshore, but are set up in India and have grown to a level where they can take benefit of offshore listing. While tech companies would be the key beneficiaries, there are certain other companies with significant US exposures, such as IT services, healthcare, global business models in commodities, chemicals, etc., that can also go for foreign listing. Even some of the telecom tower companies could look at this. Now, allowing Indian companies to list offshore directly has several benefits. Firstly, the cost of capital in India is still higher compared for a foreign corporate, which has put Indian companies at a significant disadvantage compared to their counterparts in the rest of the world. Therefore, a simple international listing regime which enables Indian companies to raise capital in markets would be of great benefit in terms of not just value, but the quality and branding that it'll bring to the Indian companies. Secondly, you'll get a global pool of investors. And so in addition to reducing your cost of capital, you broad-base the kind of investors that you can get. Even though today you can get global investors to list in Indian companies through the FPI route, the Foreign Portfolio Investment License that investors can get. Not all big global investors actually apply for it because they don't want to get into the complication of applying for different licenses in different jurisdictions. And so if our Indian companies have ability to list offshore, they get a significant deeper chunk of institutional investors abroad. Thirdly, you get a better coverage. Your analyst coverage increases if you're listed specifically, on the US exchanges. Fourthly, it also provides better opportunities for mergers and acquisitions. There are more strategies that you can deploy. For example, if you want to do acquisition through swap, where shareholders of the target company receive consideration in form of shares of the acquired company, that is possible offshore, which is not allowed in India today. And last but not the least, the hedging cost is going to be extremely important. It's extremely expensive to hedge the foreign exchange in India, and a lot of the private equity investors that invest in India have a significant issue because of the steep rupee depreciation that has happened over the years. And if you are listed in US dollars and your equities are available in US dollars, it would significantly help increase the private equity investment options and their returns in these Indian startups. With that background, let me get to Jonathan. We are very lucky to have Jonathan Stone with us today. Jonathan heads the Hong Kong office of Skadden Arps. He's got 30 years plus years of experience in M&A, in capital markets, in restructurings, in corporate finance. I've been very lucky to have him as my mentor, and I've seen him firsthand, the depth of experience he has, specifically in helping foreign issuers, because he's spent most of his time in Asia now, helping them list in the US. And, having such depth of experience talk to us today, especially, at this important juncture for Indian companies. It's a great pleasure. Jonathan, welcome. And with that, can I get to you to just help us first understand the listing process for foreign issuers in the US markets? Just how easy, how difficult it is. We all have our views, especially, after SOX came. A lot of Indian companies, I think a lot of foreign companies got scared of just the difficulty of listing in the US. So now that these markets are opening up again, if you can help us navigate through it, that'd be great.
Pratibha, can I interrupt for just a minute? Nishith here to welcome Jonathan. Thank you so much for joining us this afternoon. And welcome everybody. I think we have a huge attendance today. And I'm really happy that this subject is getting attention. And it's very interesting subject. Actually, I say that the happy days are here again because I remember in early 2000, we had an opportunity to take companies like Infosys, Wipro, Rediff, Satyam Infoway, and others on NASDAQ at that point of time. Overseas listing was becoming popular, and it was a great opportunity to have very first listing in the US to subsequent ones. And we learned a lot of lessons, and we I think dealt with the regulatory regime at that point of time, and had an opportunity to participate in reforms process as well. So it's once again very, very exciting to be, seeing this development, and I'm sure it will be wonderful, to work with you, Jonathan, and earlier also we had done a lot of work with you. It is always a pleasure to have you, and thank you for joining us today. I think and I leave it at that at this point in time. Thank you so much. Please carry on. I don't want to take too much time at this point in time. You have more interesting words to say. So welcome, Jonathan. Thank you so much for joining. Yeah.
Thank you, Nishith. It's great to see you, and thank you, Pratibha. And it's great to see so many friends and clients of Nishith Desai on this WebEx. I hope everyone is well and healthy, and getting through the current crisis well. It is a very interesting time we live in. It's particularly exciting to see the change in rules in India, which has been quite a long time barrier for companies in India, particularly tech companies and companies that may not be profitable at this current stage, but have significant growth businesses going to the US, that they have had to list in India first. Having been through the Indian listing process many times, including with Pratibha when she used to be with us, and also in her role as a partner at Nishith, and also, going through the US process and also in Hong Kong, Singapore, and seeing processes around the world. The comfort I'd like to give you is that the US process is actually not so difficult. Each of these processes have their challenges, and I think as regulators and investors get more sophisticated year in, year out, there's a bigger spotlight on various aspects of these types of transactions. But, if I look at a spectrum of how listings occur for companies in Asia, I would squarely put the Hong Kong Stock Exchange process at the much tougher end than, say, for example, the Indian IPO process or the US IPO process. And one of the main, and I class Singapore and London with Hong Kong because those regimes are based on a principle that the exchange is the paternalistic regulator looking after investors, not only in relation to current disclosure, but making sure the structures of the companies are set up in a way that helps protect investors. I think if you look at, to some degree, SEBI, but certainly in my area of expertise, the US SEC, an underlying principle of the US regulatory process, and the SEC is our SEBI, is that as long as there is good disclosure in your prospectus for your offering, and as long as the gatekeepers of this process, primarily the bulge bracket investment banks, are doing their job, that investors are in a position to make up their own minds and the regulator won't interfere. So I say that as a very broad principle. And this is why we're seeing it a lot with Chinese companies, because everyone will have read the news and the new Cold War they're talking about. A lot of Chinese companies, including our clients that have listed in the US for many years, are looking to Hong Kong for secondary listings. Alibaba did that last year. While we're seeing that, the Hong Kong process is actually much more difficult and torturous than the US process. So maybe let me kind of talk to you about what I mean by that. The US process is a disclosure-based process. It means that you prepare a registration statement, and the main part of that registration statement is a prospectus, which describes, just as an Indian prospectus does, business, industry, risk factors, what we call MD&A, which is a discussion of the performance of the business over the last 2 or 3 years, as well as certain other statutory disclosures. And most of the IPO process that is not focused on the marketing is focused on this document, the prospectus, and what lives around the prospectus. So that's the first, and I'll explain that in a little bit more detail in a minute, because the prospectus and the preparation of it actually involves not only discussions as to what to write, but a very significant due diligence process led by the investment banks, the underwriters who are underwriting your offering. The other part of the listing process is the marketing. And the marketing is essentially working out what you can do to gain interest by investors in your process. What are the investment bankers allowed to do? When can you approach investors, and what can you say to investors? Right. So that's the other part of the process. So if we step back, I was going to list who are the main players in this process. And I apologize for many of you I know are sophisticated. And if I'm coming at a too basic level, I'll try to mix it up a bit as we go along. But the main players, of course, are the issuer, the company that wants to list, sometimes selling shareholders, which in India you would normally call the promoter, the founders and the others who want to sell in an IPO. The underwriters, who really in a US process, while they notionally advise the issuer, are really the counterparty to the transaction. So they're sitting across the table from you as the issuer, and they're deciding whether or not to buy your shares. And when they decide they will buy them, that's the pricing of your deal and a firm underwriting. And then around that is a whole lot of advisors. You would have, as an Indian company, an Indian counsel, Nishith Desai. You'd have a US counsel such as ourselves representing the issuer, and the same representing the underwriter. And all these counsel play particularly important roles in the documentation process. And then last but certainly not least, and probably more important than us lawyers, is the independent auditor, the one who is there to really audit your financial statements and assist you in this process. I'm looking at some of the questions that came in as I go through this. And one question was, help us understand the process for foreign issuers in the US. For the process for foreign issuers is slightly easier than it is for domestic issuers, but it still involves at the basic level the same sort of prospectus and financial statements. And so the process involves probably first out of the gate, making sure you have financial statements and generally audited by a Big Four accounting firm. And normally you're required to have 2 years of financial statements as a foreign private issuer. It used to be 3 years, plus what we call a stub period, which is a part year period. So if your financial year is March 31st and we're doing an offering in October, you would usually have at least the first quarter, and if available, the first half. These would be audited, and in the US, they can be audited under various GAAP. They can be US GAAP, which is very common for the Chinese companies that have listed in the US. they can now, under relatively recent rules over the last few years, be IFRS. So they don't have to be US GAAP. And there is even provision for them to be Indian GAAP, but reconciled to either IFRS or US GAAP. But I would say for companies in Asia, the large majority of them have historically been Chinese and have US GAAP financials. But outside of the Chinese companies, for the odd company that has been doing this in other parts of the world, and the companies that Nishith mentioned, many of them would do Indian GAAP or now reconciled to US GAAP, or now could do IFRS. One point I will mention is the reason I mentioned Big Four is as things have happened with foreign companies over the years, and I'm thinking of Luckin Coffee, which you all will have read about, which is this fraud situation in China. I'm thinking of any other, negative situations that we've seen from foreign companies listing in the US. Investors have become more and more cautious. And, this will be particularly not only for your marketing to ensure that you're marketing to investors who are confident in your financials, but also the underwriting firms that you would interview to underwrite your deal will be much more willing to underwrite if you have Big Four audited financials. Now, I say that Luckin Coffee was actually audited by Big Four, so it's not a situation where it guarantees that there are not problems, but investors are much more comfortable as are underwriters with Big Four accounting firms. What happens is once you've appointed your underwriters and your advisors, you would have a kickoff meeting, and that really starts the due diligence process. And it's an opportunity for all the participants, the underwriters and all the advisors, to learn about your business. And the advisors who have to learn about your business are not just the underwriters and their counsel, but are also your own counsel, Indian counsel and US counsel, who at the end of this process will have to give certain assurances to the underwriters in relation to your disclosure. Once there have been management presentations on different aspects of your business, you will move into the drafting process, which usually takes several drafting meetings and drafting sessions. Drafts of the business section, particularly describing your competitive strengths and your strategy, become extremely important. And for companies in the tech sector that may not have a long runway of operation, may be relatively new, like many of the unicorns, it is particularly important to have very good disclosure from both a marketing and legal perspective on what you plan to do. What is your business model? How do you think this is unique? How do you think that this works to create revenues and over time profitability? And, when the SEC will review your registration statement, including the prospectus, and will ask you these types of questions. Once the offering document is in a state where all of the parties are happy, and that includes the underwriters, then it will get filed with the SEC. Now, for foreign private issuers, you are allowed to confidentially submit the document and have it reviewed in a confidential process. This is not available generally to US domestic issuers. However, it's good that it's available because it enables any big problems to come up not in the public domain. The SEC reviews the document from both a legal perspective and from an accounting perspective. So the document will have financial statements included, and the accounting staff at the SEC will give comments on the financials, including potentially policies that you have implemented in the preparation of your financials. And the legal folks at the SEC will give comments on the legal disclosure. Elaborate on why this business model is different from other business models that haven't worked. Elaborate on why you think these are the metrics that are most important to your business. Why are you showing these particular metrics in your registration statement, which you're showing to investors? How do they help investors evaluate your performance? The SEC process and comment process usually goes through 2 to 3 rounds. The good news is that since the Trump administration came in 2016, there have been significant changes to the SEC comment process to make it a much easier process. Now, I'm not saying that this will continue to be the case for foreign companies, but you know, in the last few US IPOs we have done, and we've done some pretty significant ones out of Asia, you know, the number of comments we were getting from the SEC were in the range of 20, 22 comments. You know, not very difficult at all to turn around in a couple of weeks and send back the registration statement for review. Back in the day, and, you know, Nishith and, you know, was bringing back memories and aging me as well, and it's in what he said. Back in the day, we certainly, as a matter of course, 50, and I remember some particularly complicated issuers could get up to 80 or 90 comments. Wasn't particularly a successful situation. The more comments you get, the harder it is to respond, because there's normally some quite difficult ones there. And, you know, more importantly, the longer it takes to respond. And, you know, if we in emerging markets know anything, time to market is critical. You know, when you're looking at the right time to market your deal, it's got to be in the right window. And if the window goes, it sometimes doesn't come back for 6 months, you know, or longer. And so I think all of these points are crucial in making sure you've got good advisors, underwriters who are engaged and experienced in your industry, and you get to a place where you can market quickly. Let me pause there, and if anyone has.
Thanks, Jonathan. I have a few technical questions, and then maybe, you know, a lot of our audience today are general counsels of companies who are looking to list. So it'll be good to talk about, you know, what preparation that they need to do in order to get ready for listing. But just in that regard, some technical questions. Firstly, you know, for our Reg S 144A deals, for those who don't know those terms, that's just basically when you have an Indian listing or offering, and you're also offering in the US, then, you know, depending on whether you're just offering to international investors, it'll be Reg S. If it's also to US investors, it's a 144A deal. So for Reg S 144A deals, Jonathan, as you know, you can have a common international counsel, which helps for Indian companies to reduce costs. Would that work in a US IPO scenario? And then when do you actually switch over to IFRS, like, or start doing IFRS accounting too? You know, does it help if you have 1 or 2 years of track record? It doesn't matter. Just, you know, add those two to the overall question of what do you do to prepare.
Yeah, no, it's a great question, Pratibha. I think that when you go to your offering, you need at least 2 years, full years of financial statements, unless you haven't been formed for 2 years. But generally, you'll need at least 2 years of financial statements, and they will need to be Indian GAAP reconciled to US GAAP or IFRS, or they will need to be prepared in IFRS and US GAAP. And then you will also need your stub periods, as I mentioned. So if you're preparing for an IPO, that doesn't mean you have to wait 2.5 years. You can go back and re-prepare and re-audit statements in those, you know, using those GAAP or IFRS. So that's fine, and companies do that, but that does take time. And it takes time for the company to get up to speed in understanding and get the people with the expertise who know how to prepare those statements. And remember, auditors are there to audit your statements. They're not allowed to prepare the statements. Sometimes issuers retain a different accounting firm to assist them in the preparation of their accounts, but the auditor has to be independent. So the auditor isn't allowed to prepare the accounts. It's only allowed to audit the accounts. So the first thing to do is make sure that you have qualified people and an advisor who can help you prepare your accounts under that gap. So that's the first thing. Secondly, apart from the accounting side of things, well, related to the accounting side of things is internal controls. When an accountant audits, they do not by default audit the internal controls of the company. They do need to look at the internal controls in order to come to a view as to whether their audit is sound, but they don't do an audit on internal controls. However, in a US prospectus, you do need to have disclosure on the quality of the internal controls. And usually the auditor will send you a management letter at the time they audit, which tells you about what we call significant deficiencies or material weaknesses. a material weakness is worse than a significant deficiency in internal controls. Normally listed companies will also retain an advisor, again, different from the auditor, to help them design and improve their internal control system. And I'm talking about internal controls over financial reporting, which is really a defined term in US law. So that advisor will help them put in place controls so that when the auditor finishes the audit, it won't be disclosing many, and hopefully any, material weaknesses or significant deficiencies. If there are some, that's not the end of the world. Most of our newly listed companies in Asia do have these, one or two. The main one we see is that there is a significant deficiency or a material weakness because the company does not have appropriately trained IFRS or US GAAP personnel. And so these are people who need to be hired over time. Another deficiency may relate to separation of duties or some other aspect of accounting. It's not the end of the world if you have that disclosure, but it is important, and the underwriters will want to know that you have hired the experts to help you improve. So the sooner you do that at the beginning, before you get people on board in the process, the better it is. That's on the accounting side and the controls side. In addition to that, on the legal side, there is a range of corporate governance that underwriters will want to know that you have been abiding by and will continue to abide by. And when I say the underwriters, I say you'll meet the banks and they'll be very nice to you and they'll want you to hire them. And this one will say we've done more tech listings than the other, and this one will say we did Alibaba, and this one will say we do Facebook. And they'll come to you as your friends and advisors, and in many ways they are very helpful advisors. But as I said at the beginning of this webinar, they are also gatekeepers of the capital markets for the United States. So an underwriter who's negligent in its job and doesn't do what it should be doing, apart from being sued, can get in serious trouble with the SEC. Okay, so they are gatekeepers of capital markets, just as your lawyers are, right? Your lawyers are as well, and your auditors, your Big Four auditors. So they will, but the underwriters as the principal gatekeeper and also the counterparty who will buy your shares and on-sell them to the public and slap their name on your prospectus, they will want to see that your corporate governance processes have been sound. So for example, if you've had a lot of related party transactions, they'll want to see that there's a proper process. They'll want to see that the process isn't imbued with people who could be seen as biased because they're on both sides of the transaction. And this comes to my next point, which is one thing that is very comforting for underwriters and very comforting for investors is if they've been independent directors and maybe even independent investors, reputable investors in your company prior to IPO. So if you have big name private equity firms or VC capital investors who are well known in the market, particularly in the US, that's a positive. Normally when they come in, will require at least some level of oversight. They may be on your board and they may require some level of independent directors on your board. Once you list in the United States, you'll be required to have independent directors. Normally, most companies have 3 independent directors, foreign private issuers. US companies must have a majority of the board independent. Foreign private issuers are not currently required to have that, but normally they appoint at least 1 prior to listing, 1 within 3 months of listing, and the other within a year of listing. And so the more independent directors are reputable directors, reputable investors who have been on your board and involved, procedures for corporate governance, which Pratibha and the Nishith team could advise you on well as Indian companies. How do you deal with related party transactions? How do you deal? Is there a whistleblower policy for employees? Is there an anti-corruption policy? Is there a sanctions, protection against sanctions policy? All these kinds of things. If these have been running, for the life of your company, or certainly a significant portion of it, it's a very good fact. Other things to prepare. I think that the other point I'll make is, often we're seeing, and you mentioned unicorns, we're seeing these days, and we represent a about 60 listed companies from China, just out of our Hong Kong office, listed in the United States. So we have the leading market share of US listed issuers in the China market. And I will say a lot of these companies are great tech and biotech issuers, and they have entrepreneurs as their founders, who are great business people and very impressive people. But, you know, as general counsel, sometimes you need to, you know, pull in your boss or pull in your promoter a little bit to get them down to the nuts and bolts of what investors see. And I'm picking an example out of the year, but the WeWork situation is classic, because the WeWork situation, which we've all read about in the newspaper or online, really is a situation of a visionary founder who just didn't stand up well to investors, and you know, as a result, and you know, was, I guess you might say, looking at it, you know, stepping back, one could say was got the confidence of SoftBank, you know, and its owner, and you know, many investors. So I think, you know, if you look at that situation, one way to prepare internally is to ensure that your promoter, your CFO, your COO, your executive team, including the general counsel, are prepared for what this will involve. And this process does involve a lot of management time. For all the, you know, law time and auditor time and investment banker time it involves much more management time. And so another thing I would do to prepare is try to prepare your founder, CEO, for the time that's going to be required to frame the story, to enable the working group to understand what it is the founder sees, what is that vision, to help the working group, you know, put it down and standard. You know, they don't have to do all the nitty-gritty work. That's what we're for. Their business is presented to the public is consistent with their vision.
Thanks, Jonathan. That's really helpful. But you know, equally important is for us to understand what are the key pitfalls, right? It is something, again, like I said in the beginning, that Indian companies worried about, because we know our Indian laws, we know what SEBI wants, or what you know, the Ministry of Corporate Affairs wants. But just, you know, broadly, what are the big issues you've listed, right? And post-listing, the ongoing cost, SOX compliance, other regulatory work, for example, insider trading is a much bigger issue in the US when you're listed than, you know, we face here. So, you know, before you take the decision, you need to know not just the process to list, but what happens after that you need to worry about today. So you talked about related party transactions, but what else?
So related party transactions, I think, you know, is really governed mostly by Indian law. There's disclosure you're required to put in prospectus, but of what that law says, you know, what US law requires. I think if you're looking for the pitfalls of US listing, you know, what are the things that cause people to say, no, I want to go to London, or I want to stay in India, or I want to go to Hong Kong? I would say, you know, SOX compliance, which is the Sarbanes-Oxley Act, SOX compliance is not altogether one of those things that our issuer clients find most difficult. And I'll tell you why. The worst part of SOX compliance is an internal control audit. It's an audit that has to happen every year to your internal controls. They call it a 404 audit, which is after the section of Sarbanes-Oxley. And a 404 audit is quite difficult to do and quite time consuming, and the attestation by the auditors on an annual basis is quite onerous. The good news is that most foreign private issuers that go, unless they're very large, i.e. have revenues of more than $1 billion, most foreign private issuers are exempt from the 404 requirements of SOX. And those are foreign private issuers who come within a classification called an emerging growth company. And the emerging growth company came in the Jobs Act, and that was one of the mechanisms passed to enable things to be easier for foreign companies. So many of our clients in Asia, and I'm sure many of the Indian issuers, will be emerging growth companies. They will have revenues of less than $1 billion. It's really $1.07 billion because it goes up every year with inflation. And if you're an emerging growth company, you get to do a couple of things: miss out on the 404 audit for so long as you remain an emerging growth company. You also get to test the waters, which is effectively you get to market your IPO in certain ways even before you've filed your registration statement publicly, although it has to be very controlled by the banks. But there are certain things ECGs are allowed to do. The 404 audit is one of the SOX compliance issues. I would say that the rest of the Sarbanes-Oxley Act is that onerous. The Indian issuers, any issuers can get into trouble with, and Indian issuers should be mindful of, I would say 2 areas. One is class action lawsuits. So if you do your IPO and the stock price drops, and it drops dramatically, the US has a legal system where there are law firms, not law firms like ourselves, Wall Street firms, but small plaintiffs, what we call plaintiff side law firms, who spend all their time looking for companies that have recently IPO'd and whose stocks have gone down, and they immediately file class action lawsuits against them who invested in the IPO or shortly after. Plaintiffs' bar in the US can cause problems, and that gives class action lawsuits by them saying, well, this disclosure you had in your prospectus wasn't quite accurate, or you had to restate your financials, or there's an issue here you didn't tell us about, your stock has fallen, and the investor class has lost money. Now, a number of US-listed Chinese companies and other companies around the world have been subject to class action lawsuits. The good news, is that you can take insurance, and we advise all of our issuer clients to take insurance for certain risks of lawsuits. And there's a discussion, depending on the size of the IPO, what level of insurance you would buy. And generally, in the large majority of these cases, when they have come up, we've been able to settle out the lawsuits for less than the insurance. So the biggest cost has been the deductible or the retention under the policy. So, I would be, not being upfront if I didn't say to you that compared to markets like India, Hong Kong, Singapore, even London, class action lawsuits is probably the biggest issue for companies listing in the US. I'd say that the other issue that I think comes up for foreign companies listing in the US is SEC investigation. And SEC investigation most often happens in the area of what I'll call FCPA. The FCPA is the Foreign Corrupt Practices Act in the United States. And if you list in the United States, you become subject to the Exchange Act, the Securities Exchange Act of 1934. And under the Exchange Act, there are anti-corruption provisions known as the Foreign Corrupt Practices Act. And that statute basically says that if there is an episode of corruption, i.e. public corruption, of providing bribes or payments, graft to officials of a government, it could be an SOE or an official of any official of a government, that you could be liable. And if companies get into problems with these kinds of compliance issues, then there can be both class action lawsuits for failing to disclose it, and there also can be investigations from the SEC. So that's the other area. I would say those are the main pitfalls. When I was talking about corporate governance and different policies, anti-corruption policy and making sure there's education on anti-corruption, and both you have your lawyers come in and give a seminar to your employees and talk about these kinds of things, which, by the way, most private equity firms or venture capital firms that have invested in you pre-IPO would require of you. But these kinds of things are also important to do. I would say the regulatory burden, the main regulatory burden, again, for foreign private issuers, it is a lot easier than for domestic companies. In domestic US issuers, a Facebook, a Microsoft, they have to issue quarterly results on a Form 10Q, which are reviewed, and they have to issue what we call a Form 8K whenever a material transaction occurs, whether it be M&A, for example, or a material loan facility, or a change in directors. And then they have to issue a 10K, which is an annual report, which involves disclosure similar to a prospectus on an annual basis. A foreign private issuer only has to issue a 20F, which does have quite detailed disclosure and usually will involve your lawyers helping to prepare that. But there is no legal requirement, if you're not making an offering of securities, to issue quarterly reports or half-yearly reports. Now, that said, for virtually every company in the tech space, biotech space, companies normally, as a market matter, be required by your investors to issue at least a quarterly earnings announcement and some level of disclosure on how your business is going, because that's what the market demands, not because of legal requirement.
Very, very useful, Jonathan. I am getting a lot of questions, and I still have a lot of questions for you, but I'm getting a lot of questions on the Indian aspect of the easing of the norms. So I'm just going to quickly bring in Prashant and then come back to you for more questions.
Sure.
Prashant, do you want to firstly just outline what is the current regulatory framework that we already know for companies listing in abroad, and what is expected?
So, in terms of the current regulatory framework for Indian companies to list securities overseas, I mean, the only option that's available to them is to list through the depository receipt scheme, which was, I mean, something that was introduced back in the 1990s. However, it underwent a lot of reforms, and a new scheme was prescribed in 2014 that allows for ADRs and GDRs to be listed on exchanges abroad. ADR being the American Depository Receipt, which is a security issued in the United States and traded on their exchanges, whereas GDR is a Global Depository Receipt, which can be issued in all other FATF compliant countries other than United States and can be traded on their exchanges. Now, under the scheme, either a listed company or an unlisted company, a private company or a public company is allowed to issue their ADRs and GDRs in foreign market. However, in practice, and also because of the restrictions imposed in other delegated legislations, only the listed companies have been allowed to undertake these transactions in foreign market. And in order to do that, they are required to engage a domestic custodian in India who would hold those securities, which would act as underlying for the receipts to be issued. And these receipts will, in foreign jurisdiction, be issued by a foreign depository, which could be a DTC in United States or Euroclear in Europe. And through them, these depository receipts can be issued to the investors, who ultimately, I mean, and in parallel, these receipts can also be listed on the exchanges there, which can then be freely traded. Alongside, the investors also have an option to convert these depository receipts that are listed on the exchanges there, and which can be done with the help of the foreign depository through whom these securities were issued, and the depository in turn would consult with the custodian here in India, and the securities that are issued as underlying to these depositories are typically kept as a separate pool and are not traded till the time those are converted. And once the conversion happens, then they become tradable on Indian exchanges as well. So that in a nutshell is what the DR regime that we have in the country at this point. What has been proposed is something that goes back to 2018, when SEBI had constituted an expert committee to look into the viability of how can foreign companies list on Indian exchanges and how Indian companies can list on foreign exchanges. And there they had highlighted some of the policy issues that that may arise when these proposals are to be legally implemented. And one of the concerns was around the foreign exchange restrictions that we have in the country. I will touch upon that in a little while when I talk about the practical challenges. But in order to implement what was proposed as part of this expert committee proposal, certain amendments have been proposed in the Companies Act by way of the Companies Bill of 2020 that was presented in the Parliament earlier this year. What it proposes to do is it lays down the enabling framework for Indian companies to be able to list overseas. However, it limits this option only to public companies in India who can list their securities overseas. The class of securities which can be traded or the class of public companies who can list their securities overseas are yet to be fine-tuned, and this would be done by way of delegated legislation yet to be prescribed in this regard. In addition to this, there are certain other conditions that are applicable on Indian companies as part of their regular compliance, which could be a hindrance when those companies are listing their securities overseas. So a proposal has also been made that as and when required, certain exemptions may also be granted with respect to those provisions, and those provisions include broad provisions around issue of prospectus or allotment of securities, or the types of securities, the dividend to be paid with respect to equities, or the beneficial ownership of those securities with whom it lies, the disclosures around that. So there are certain broad criteria that have been prescribed under the Companies Act at this point in time, and depending upon the requirement and how the entire layout is prepared in terms of how this listing would happen overseas, government may come out with notifications that may grant certain exemptions. So that's what the current regulatory frame looks like, and a lot of it would have to be fine-tuned by way of the delegated legislation that are yet to be prescribed. And I'm sure before that happens, a lot of deliberations would also happen on the practical challenges that may arise on this issue. So over to you, Pratibha.
So do you want to then talk about those practical challenges?
Sure, I can take those up as well. So, unlike other developed countries where the capital convertibility is something that's freely permitted, in India we have certain restrictions, which is where most of the challenges when it comes to listing these shares overseas would lie. Say, for example, today, as far as investments into listed Indian companies are concerned, it is limited to a foreign portfolio investor that is registered with SEBI or a non-resident Indian. A foreign direct investment in listed shares can be made only if those investors have control over the entity. Now, so the question that arises when the shares of these Indian companies would be listed overseas, whether those limitations would still be there, or whether any investor from that jurisdiction or from any other jurisdiction would be able to invest in the shares of that Indian company. With respect to NRIs, today there is a restriction on NRIs to hold DR. But once the shares are listed on global exchanges, whether NRIs will be able to invest in those shares or not is still a question that will have to be answered by way of delegated legislation. Then other aspects that needs to be looked at is the way SEBI regulations are applied in India today. It is either on a listed company or a proposed to be listed company. Now, the definition of listed company, earlier it used to include private companies also who had their NCDs listed. But in a recent announcement by the finance minister, she clarified that going forward, if your NCDs are, if it's just your NCDs that are listed, you may not be regarded as listed entity. So maybe a little tweaking of the definition of listed company would also be required to include your overseas listed entities. And if that is done, then other SEBI regulations which apply on listed companies in India, such as takeover code or your insider trading regulations, there may be possibility that it may be in conflict with the laws of overseas jurisdiction where your securities are listed. Then maybe a mechanism to resolve conflict issues arising because of that would also have to be thought through. And then to ensure that there is a smooth transition of shares being issued and being provided to the investors, the custodians may also have to create a presence overseas, or they may have to enter into an arrangement with the depositories outside India to ensure that a smooth transition of these securities take place. And so these are some of the practical challenges that, unless fine-tuned, I mean, we feel that it is going to take some time for the process of overseas listing to become a reality.
Thanks, Prashant. Nishith, I think you have some practical insights into all these issues, having done few of the earliest ADRs.
Yes. I think it's really fun to be in this particular session, and as you know, we learned a lot of lessons. Taking Infosys on Nasdaq, Wipro, New York Stock Exchange, and then Rediff and Satyam Info, SIFI, all on Nasdaq. So I think some of the things that came up for the benefit of those who have not done this before is that first you have to decide whether you want to go on NASDAQ or New York Stock Exchange. There is a lot of debate at times. And of course, tech companies often end up at NASDAQ, but there are other reasons why, like Wipro went on the New York Stock Exchange, many other businesses. And number two, very importantly, lawyers have to be very creative. And at last minute, many issues come up, which, the problems are, you cannot imagine. Because we had situations constantly when market was going up and down, and like Nasdaq was about to drop and all that thing, and we had no time. At that point of time, one issue came up of the conflict of the Indian law with the US law. So US bankers and lawyers were saying that you have to issue shares. An Indian company said unless we receive money, we cannot issue shares. So under Indian Companies Act, you have to receive money first, and then issue the shares. And those people said that we had to. So last minute, this kind of issues came up. We had to create a special mechanism for that and stuff like that. Second interesting thing, I think Jonathan mentioned about class action suit. In one of the IPOs, the one of the directors had said that he holds a degree in management, whereas he was holding diploma. Okay. And notice was served after, because once the market drops, just bear in mind there are many shareholders who want to launch a class action suit to, because the price will drop. So they will try to blame your disclosures, and they'll come after you. So one other situation was that you have to be very careful what you write, whether degree and diploma, that itself became an issue. Third interesting situation I had. We were taking company on a New York Stock Exchange, and last minute an issue came up. The US lawyers say that this particular word, and cannot be used. It's complicated, and we have to use the use of simple English language. I think Jonathan can say a word or two on that. And on that one word, there was so much discussion going back and forth, and we are concerned about the sensitivity of market. I had to literally take a Concorde flight, go to New York in the morning, Sunday night, Monday morning. Whole day we had debate, discussion. At night we had to resolve. Otherwise, we would have lost the premium of the market. One of the reasons why people go on foreign market is, is even a good premium. There are two main reasons, and Jonathan can say more. But one reason why you go overseas is, of course, often the foreign market is more. It can give you premium as well, because liquidity is better and stuff like that. And second thing is, it gives you a huge brand. So if you are in the US market particularly, I think another purpose of the overseas listing is it gives you high level of profile. And we had to resolve these issues at last minute. And so it is very important to understand that it is not just the technical knowledge of law that is required. Your ability to solve problems at the last minute when the market is likely to be very volatile or otherwise, at that point of time, you have to solve the problem. If you don't do it, you lose the momentum. And I think we have seen a number of companies that could never go on and list because the delays happen on some of these things. So I thought I'll just share with you some of these experiences. And also we have done quite a bit of flipping. At one point of time, markets were not good in India, and we had to turn Indian company into the US company and became US, and then took on the US markets. And other thing we've encountered early on, of course, now situation is slightly different, is that most of the Indian companies felt that we are a great company because we are declaring dividend. Whereas in the US, it is not necessarily so. You want to build a company, you want to invest back your profits into the further business. So, it's not necessarily always a great idea to show that we are a dividend-paying company. But I think value creation and value generation is very, very important part of the whole game. So I don't want to take too much time at this point in time, but there are a lot of stories that we can discuss. Jonathan, sometime we can sit together and share experiences. But ability and to be creative, is something also that is wonderful, and together we co-create these ideas and solve the problems. But we have so much of experience now, particularly with the US market, which has very high standards, and we have to be very careful in everything you do. But at the end of the day, I have seen that most of the US companies that have gone to the US market have survived. Most of the GDRs have not survived. Maybe, I don't know, 40, 50, or I don't know how many are still traded or otherwise, but most of the US listed companies are still trading. So quality of market is also very important. And I thought I'll just share with you this few thoughts. Sorry for my interruption, but
No problem. Thank you for that, Nishith. All that experience that you and Jonathan have is extremely important. And again, this sounds a little self-serving, but for the US market, Jonathan, you would agree that the quality of your advisors becomes extremely important. I think it does matter for SEC to see what is investment bankers and what law firms you're using for the advice. Because as you mentioned, it's a disclosure-driven process more than anything else. It's whenever I compare the U.S. securities laws versus Indian security laws, you have that just one provision that has been interpreted over time in terms of ensuring there's not material misstatement as far as U.S. disclosure and U.S. listing is concerned, and everything revolves around that. Compared to the long objective ICDR framework that we have in India, where we have to disclose all litigations, and it's quite extensive. So I might not be wrong in saying it really is very, very important, and this is not where you would cut corners if you're listing in the US, to ensure that the bankers and the lawyers, the US lawyers, all specifically, who are giving you the opinion that you have not made a material misstatement and do your due diligence, becomes extremely important.
That's absolutely right. And thanks, Pratibha. And Nishith, those were some great tips you were talking about in your experience. I love the story about the Concorde flight. I don't think any of us can take that now. But I think one of the things is the SEC is not nearly as tough on plain English as it used to be, which I remember all of those years when you couldn't use a word of 3 syllables because they wanted you to say it in 2 or 1. But one thing I totally agree with what Pratibha is saying. I mean, I think to many of the corporates and the folks from companies who are listing, I think it's very important to, understand a couple of things. One is you should work with advisors who have deep experience representing companies. There are law firms who have experience representing banks, and there are law firms who have done both, and there are law firms who do more on the company side. I think both with Nishith, while we do represent banks on deals and we know banks well, we are viewed as leading firms for representing companies, representing the key, whether it be in the tech industry or biotech or just across the board. Skadden is known as the law firm to the Fortune 500, and in the tech world to some very large tech companies. And I think in Asia, by our position in doing deals for major Chinese companies like cCep and Baidu and JD, all of whom are corporate clients of ours, this is a very important point for companies. You need to have a firm that's used to dealing with issuers and used to dealing with companies, because they have a different mindset and a different outlook than the banks. I think the banks and good bankers and good investment banks are incredibly important. They are key to this process, but don't forget your counterparty, and don't forget that they have a slightly different interests from you in the transaction. That's not to say these transactions are adversarial. They are not. They're very cooperative. Everyone's rowing to the same tune. Everyone's trying to get to the same place. So they tend to be very cooperative and very easy transactions. The most But there are areas where there's pressure to put in disclosure on an issue that the company may have, that the banks will put a lot of pressure on for more disclosure. And then it may not be the bank as you know, it may be the in-house lawyers or the deep departments at the law firms who are, sorry, at the investment banks who have their deep in-house legal department pressuring to have a lot of disclosure on something. And it may not be completely in the issuer's interest to disclose it in that way. And so, you know, you need to have, while the law firm on your side is also a gatekeeper, they need to be a firm used to taking into account the needs of entrepreneurs and the needs of companies. And I know Nishith is the leader of that in India. And so it's just very important to make sure you have the right set of advisors for that. But look, it's a good process. And I think it's a process, you know, this change in the laws of India is very positive for companies who want to look at the option of the US.
Luckily, you know, 50% of the time we represented the bankers and 50% time the Indian companies. So at least we have some understanding of both sides. So it helps us to prepare the Indian companies that what bankers are likely to expect. Also, one of the thing I think you mentioned already about it, also we find that different bankers have different strength. So who to select as banker and where the domain knowledge lies and understanding of the industry lies also becomes very important. And together with people like you, with the company and all that, you know, it is just not about who is on what day, what is the depth of the industry understanding. That also makes a lot of difference, you know. So it's a real interesting thing to work on this kind of things, you know. So
Sure.
thank you so much for sharing your perspective.
I'm gonna quickly just extend the time a little bit, just by 10 minutes, Jonathan, and just address some of the questions. We're answering all the domestic law related questions online itself, but some are for you. First one is with regard to the timeline in terms of how long it can take for the process for US listing versus Indian listing, you know, which can be anywhere between 3 to 6 months, can extend to a year. And the taxing and pricing considerations for US listing.
Okay, on the first point on timing, if the financial statements are done, and normally the financial statements will be done before you kick off the process, but if the financial statements are done, you can do a US listing, assuming everybody's rowing to the same tune and everybody's on board and experienced, and the company has relatively few issues. It's not overly complicated. And by that, I mean, for example, if you've done numerous acquisitions, then you might need pro forma financial statements. If you have, you know, if you have lots of lawsuits or some other sort of complication, or you have you know, all your IP is owned by the promoter and it's licensing them in and these kinds of issues, then it may take longer. But you can do a deal in 4 months. Usually it will take a little longer. But, you know, if we see the Hong Kong processes taking 6 to 9 months at the end of the day, you know, they say 6 months and they usually take 6, 7, 8, 9 months. Xiaomi took, I think, 6 months, and that was, you know, our client, and, you know, they went to Hong Kong. But it's very unusual in the Hong Kong process. But the US process, 4 to 6 months is a usual time period. Your other question, Pratibha, sorry?
Just the pricing and tax considerations. I think from an Indian law perspective, I can tell you there would be, you know, amendments required to ensure that, you know, we're not going to be double dipping. But I think that's something that the SEBI committee's already suggested in terms of certain tax concessions that would have to be made to ensure transfers offshore are not subject to Indian tax. Currently, under the current laws, it would be. But any other pricing considerations that would need to be kept in mind offshore?
Yeah, I mean, I think on tax from a US perspective, I think if you don't have operations there or a place of presence, you're not a US tax resident as the company, then US tax should not feature in your deal, except for the fact that there will be US tax disclosure in the prospectus. And for example, our firm prepares that in every offering we do, or if we're on bank side, you know, the Issuers Council prepares it. And so there'll be disclosure, and that's really disclosure as to the US tax consequences for US investors. However, usually the tax consequences are driven by, in the case of Indian companies, Indian law, and NDA will be the experts on that. I think other pricing considerations, I think it's very important to be a little skeptical of the pricing expectations that the banks tell you when they're pitching the work. But you should definitely, look at how the banks are modeling your pricing. How do they see the pricing being modeled? How will they tell, how are investors looking at your, at pricing? And if you're a, pre-profit profit company, you're in your very fast growth stage, a tech company or biotech, and you're looking for pricing off revenue or other metrics, you need to get a very deep understanding from your bankers as to how they believe investors would look at the valuation, and what the comps would be that are in the market. If these in the US or Europe or in developed markets, how they would be transplanted into the a party in India, a company in India, how they will look at the Indian macroeconomic situation in marketing, and these kinds of things. So I think these are all the issues in pricing that it would be very important for you to understand when you're selecting your banks.
Sure. Thanks, Jonathan. Another question we have is with respect to any additional monitoring required for Indian regulator SEBI in case of US listing. I can answer this. Currently, SEBI has not come out with its guidelines for offshore listing. If they cover an offshore listing to be considered to be a listed company in India, then all the continuing listing obligations will be applicable to Indian companies that are listed only offshore also. But as practitioners, we have been asking SEBI to make significant exemptions from Indian laws. And Jonathan, you will understand this, just compared with the other Asian companies that you represent. If you have the same laws applicable to an Indian company that's listed offshore as to an Indian company that's listed in India, then you're complying with the regulations, the listing obligations of two countries and two jurisdictions. So, have you experienced what happens when, so for example, if you're subject to the insider trading regulations in India, which can be very, very objective and prescriptive in nature versus, the US insider trading regulations, and then reconciling both, and then, making those submissions in your 8Ks and your 20Fs, how does that work out?
Yeah, well, normally, I mean, the dual listing question's coming up quite a bit now because of these Chinese US listed companies that are all looking for secondary listings in Hong Kong, partly because of the new attitude of the US to these companies and some of the scandals. There's a law that passed the Senate a couple of weeks ago called the Holding Foreign Companies Accountable Act. And this was really aimed at Chinese companies. The biggest conflict that exists, and I don't think it exists for accounting firms in India, but in China, your Big Four accounting firm that audits you will not be, Deloitte US. It will be Deloitte India or EY India, but there will be people involved from EY or Deloitte or whomever in the US reviewing the audit, but the audit report signed by the Indian firm. In China, the Chinese firms of these Big Four are not permitted to share their work papers or be reviewed by the US regulator under Chinese secrecy laws and security laws. And so there's a big conflict between what the US regulators require, which is access to audit work papers if they do an investigation, and what the Chinese regime's laws say. And this is one of the reasons for this new act or bill that's gone through the Senate and is now being considered by the House. But I think, a more practical question on insider trading and things like that. Insider trading would normally come to, it can be an issue under both laws. And, if you're a Indian company and you've got two listings, one in India and one in the US, you would normally have to comply with both laws in trading. You'd have to comply with both laws in your reporting. Generally, we've been able to find a way to bridge the Rubicon in this issue. Skadden was the first firm to take a Chinese company to a dual listing in Hong Kong, Shanghai, and the US. We were the first one to take an Indonesian company and a Hong Kong company as well. So we have a lot of experience bridging the regulatory systems. And yes, issues come up, but when you do a dual listing, in my experience, the issues get dealt with. And I think US regulators will be happy to see Indian companies coming to list in the US. They'll be pleased that with this kind of negativity on the Chinese companies, that there is a respected ally and a democracy and an open, a big ally of the United States, where a company with a very large growth economy coming to look for money in the United States. I think they will like that, particularly under the current administration.
Thanks. That brings me to the last question, which is, do you think we can get going right now as Indian companies? Let's say, we get all our laws cleared. Given the COVID situation globally, do you think Indian companies should start getting to list or wait for the pandemic to have some sort of visibility for an end? Because we are seeing great liquidity, especially in tech stocks in the US, and a lot of liquidity flowing into the markets. So are you getting a sense what other foreign private equity issuers are doing?
Look, I think that definitely the things we talked about in getting prepared, financials, policies, getting the mindset right of everybody in the company, and getting prepared, making sure you're well prepared. I think that for companies, there's always a benefit to starting a process. Look, starting and stopping the process because the market's not right, and restarting and stopping again, that does involve extra expense. But the expense generally, and I know it's easy to say as a lawyer, but we're a much smaller expense than the expense of not getting the right market window. And I think at the end of the day, and Nishith was saying this, that when he was looking at this back in the 2000s or the internet, boom, that really, getting the market, meeting the market window and getting out there is the most important thing for pricing an IPO. You want an IPO that's successful, that's not priced too cheaply, but is priced well enough to give a little bump to investors and that people view as a success. That's a great way to start to introduce yourself to the investor market. So look, I think the benefit of starting now is that if the window opens, be it October or whenever, you'll be ready. If you wait till the window opens and start then, you'll be working on your prospectus and your filing at the same time as a lot of other companies, and you won't be ready to go at that time. So the window could close.
Yourself ready is your advice.
Yeah, generally I would say get ready, be prepared for a little bit of additional cost if the market window closes and you have to update your disclosure. But compared to the cost you incur of not meeting the right market window, and worked in emerging markets 20 plus years now since coming out from the US, and where every time I see a company not go at the right market window, every time it's a bad result for the company. Every time. When even in the bond market, when I see companies say, "Oh, I don't like they're offering me 9%, I don't want to pay 9%. I was hoping for 8.5%," and they stop the deal and they say, "No, we won't do a deal." Every time when they come back a year later, it's 11 normally. It's not 8.5. So I'm a big advocate of being ready to take the market window.
Yeah, don't be penny wise and pound foolish. Jonathan, it's such a pleasure to have you. I feel like I want to do a full another session with you purely on the debt markets, because you have such a great depth on, high yield bonds, perpetual bonds, something that India is grappling with. So, we might consider a follow-on And there are a lot of questions on debt securities that I'm not bringing now because we're purely focused on equity for today. But we might consider that. But thank you so much. Nishith, you have a last word?
Yeah, just one word. I think, you see, it's the right time to build a story. And that is, we have to create interesting story about the company and positioning that matters more. And third thing, the value drivers now are going to be EESG, ESG, and stakeholder. So the whole concept from shareholder to stakeholder has assumed significant importance in recent times. So when you weave a story, I think you have to factor into all these things. So that takes a little more time, at times to not only you have to have a story, but you have to back it up. And therefore, it's the best time to step back for a minute, think how you want to unfold your story. And it should be interesting. You have to understand what kind of positioning you want and what are the new value drivers in the coming times. It's just not about profit and loss, but it's about what kind of value systems and the ethical issues, and the ESG is becoming the name of the game. So all these are the new value drivers, which I think our audience, I think, should bear in mind. So it's that's a good preparatory time at this point in time. So by the time we get over this pandemic problem, you're almost ready to get better premium on the foreign market, and particularly the US. And thank you so much. Thank you, Jonathan, once again, and thank you all the participants for being so patient. We extended by 15 minutes, but hope that was useful. Thank you, Pratibha, Prashant, and everybody. Appreciate it was very interesting. Thank you.
Thank you
Thank
very much.
you.
Thanks, everyone.